flashlight were very difficult to observe. So during a meeting that I had with Ms. Freud, we had some photos of the flashlight where prior to the stains being tested, and I used that to identify the locations on the flashlight where I would circle and then swab and do my testing.
Without the photos, before we took those out, what were you able to discern from the flashlight as to where did you start, where did you swab?
That was very difficult. There was only one stain that I would maybe test without the aid of the pictures.
And without
presumptive test is a test that we use to identify whether a substance could possibly be present. And the reason it is a presumptive test is because we know that other items or other things will also react with our chemicals. So it's just a good starting point for us to use to figure out whether the substance we're testing for is present and then move forward with further testing.
Of the 6 stains, how many of the stains tested presumptively negative for blood?
5.
And how many of the stains tested positive?
1.
Which stain was that tested positive?
That was stain F.
And would you just show the court where and describe for the record where on the flashlight that stain was found?
Sure. Here's a picture of the base of the flashlight. Stain F is marked towards the top where the lens area would be. And this is kind of a general photo. And here is a close-up of that stain with a ruler.
And what can a presumptive test for blood tell us?
No, it is not.
Today, can DPS do what it did in 1985 and type that substance into ABO, AB, ABO, AB, yes, for all of the types of blood?
No, we cannot.
Why not?
We no longer do that testing anymore. We do a presumptive test and then we move straight to DNA.
And you had given me such a good example to explain that difference to me with the knife example with blood and then potentially saliva over that. Do you remember telling me that?
I do.
Could you give that example to the court?
The reason a presumptive test for blood is only presumptive and it's not specific for human blood is because it tests for hemoglobin, which is not only found in human blood but also non-human blood as well. And there are also other chemicals that will react with our chemicals. So let's say that you have a knife, for example. You went deer hunting and you cut open the deer, you got the deer, and you may have some blood on your knife. Well, it would test positive for blood, but it's not human blood. Now let's say by chance that an individual spits on that knife to clean it, and it's a human, so you have human DNA that may be present on that knife, but you still don't have human blood present. So what we would get is a positive presumptive test for human blood, but once we run DNA on that, we would also get a human DNA profile from the saliva. So we don't have human blood, but we have a human DNA profile. So we know that the presumptive test is not going to necessarily mean that human blood is present, only that blood could be present, but the DNA is going to tell us that we got DNA, but not necessarily from what substance or what type of body fluid.
So of the single stain, stain F, that tested presumptively positive, based on that result, can the state of Texas say confirmatory or conclusively that that is a human blood stain?
No, we cannot.
And also, and I know I had previously given you a copy, and so the availability of her profile is no longer an issue in this case. Is that correct?
That is correct.
And so let's start with talking about your results on the receipt. So that'll be on the second page of Defendant's Exhibit 59. Would you please tell the court what your results were for the receipt stain, the stain on the receipt, please?
I was able to obtain a partial DNA profile from the stain on the receipt that was consistent with being from one person.
And would you explain to the court the likelihood ratio that you got regarding stain A on the receipt?
Obtaining the profile that I did is approximately 1,730 times more likely if the DNA came from Ms. Bryan than if the DNA came from an unrelated, unknown individual.
And when we're looking at likelihood ratios, what is a strong likelihood ratio and what is a weak likelihood ratio?
In our testing, we have 3 different zones that are ranges that we look at. Anything above 1,000, or a likelihood ratio above 1,000, is going to be an inclusion. Anything between or less than 1,000 but greater than 0.01 is going to be inconclusive. And anything less than 0.01 is going to be an exclusion, where the individual is not a contributor to the profile. Anything above 1,000, again, is kind of you have the range there, but a larger number greater than 1,000 is going to indicate a stronger association to the evidence than a lower number closer to 1,000.
So with the likelihood ratio that we have in this case of 1,730 times, how would you rate, so to speak, the strength of that likelihood ratio?
While it does constitute an inclusion, it is not as strong as a number that would be higher.
And moving down the report, let's talk about the underwear. Would you just tell the court the results that you got on the underwear and the DNA report, please?
Yes. The DNA profile that I obtained from the underwear was partial, meaning that I didn't have information at all of the locations that I examined, and then it was interpreted as a mixture of 2 individuals. And I was unable to determine whether Ms. Bryan or Mr. Bryan was a contributor. Therefore, my results were inconclusive.
Based on your review of Defendants Exhibits 59 and 60, what, if any, of your opinions have changed?
None of them.
Before I walk through with you what Ms. Janice has kindly now marked as Defendants Exhibit 1 and 2, did I also share with you that Ms.
for impact events, or, for spattering events, whereas the flashlight is designed by its construction to be held like a miner's light or like a lunchbox light, as I previously testified to, and it's not designed to spin around and receive multiple directions by its nature. And so that he included those two as being the same, my opinion still is that those two things are completely different, in that by holding the flashlight in one hand and firing a weapon in another hand, that by how someone would have to be in order to receive that spattering event, just like the demonstratives that I created, that spatter is still going to generally come back towards that flashlight in a predictable manner, of which you are not going to get spatter stains going from the back of the flashlight to the front of the flashlight like that we see on the scene.
And so, just being practical, the flashlight's got a handle, it's there for a reason, right, to hold?
Correct.
And so, is there any way that somebody holding the flashlight, especially in the manner that was testified to under the state's theory of trial, that you're going to be spinning the flashlight by the handle like a fan?
No.
And so you still have, and you and Mr. Bethel still disagree, correct?
Yes, ma'am.
I'm showing you what's now been pre-marked as Appendix Exhibit 1 and 2. Would you tell the court what that is, please?
It's an affidavit that's signed and notarized by Robert Dorman, dated August 20th, 2018. Oh, my apologies, September 13th, 2018.
And when did I ask you to review that?
It was a couple days ago.
And is this be a true and correct copy of Mr. Foreman's affidavit from September 13th that I had asked you to review?
Yes, ma'am.
Your Honor, at this time I'd offer Defendants Exhibit 1 and 2. Excuse me? No.
State has no objection. It just made it.
Ms. Rossi, would you please read the first paragraph of Defendants Exhibit 1 and 2 into the record for us?
Yes, ma'am. My name is Robert Dorman. I am over 18 years of age, competent to make this affidavit, and have personal knowledge of the facts stated herein.
And the second one for us, please?
I conducted a review of the August 20th, 2018 court testimony pertaining to my bloodstain analysis of a homicide scene, the Vicki Bryan case, I conducted on 10/15/1985. The testimony indicated that the current experts in my field believe my analysis was incorrect. They stated my techniques and methodology were wrong. Therefore, my conclusions were wrong. As a result of this, and the fact that this was my first major case, I worked utilizing bloodstain analysis. I will agree that some of the techniques and methodology were incorrect. Therefore, some of my testimony was not correct.
And you have reviewed Mr. Foreman's 2015 affidavit, correct?
I did.
And in your opinion and reading of it, does this appear to be a change in position?
It does.
And you are also aware that Mr. Bethel was actually Mr. Foreman's instructor back in the 80s, is that right?
Yes, ma'am.
And so does it sound like, based on your reading, that in addition to your testimony that you reviewed, as well as that of his original instructors, that he now is admitting that he made mistakes?
Yes, ma'am.
And that's a change from his previous statements, right?
Yes, ma'am.
Could you also please read the third paragraph of the report?
I do want to add that in my basic report, I did state on more than one occasion that, based on the condition of the crime scene, that all of my measurements could not be considered accurate. I also stated that due to the condition of the scene, my results could not be considered accurate, and that all the results only reflect the possibilities of what occurred. I do want it to be known that in no way did I lie in my report or testimony, as I was doing what I thought was correct as a result of my training at the time.
And you and I say this to everybody, we have no reason to believe Mr. Foreman lied, correct?
Correct.
None of us do. But he was wrong, wasn't he?
Yes, ma'am.
And the two sentences of that third paragraph before, what does that still tell you about what he understands about this field and discipline?
By reading this statement, he still believes that the vetting and the stuff that had already been collected in some way were important in the analysis that he supposedly was trying to do. So it still shows that he still doesn't know what the correct methodology was or what he should have been doing.
It's just now that we declassified as Mr. Double says he's wrong, and you say he's wrong, tell him you say he's wrong. Is that right?
It appears so.
Oh, okay.
And Mrs. Rossi, after your review of these DNA test results issued by the DPS lab on August 30th, 2018, is your testimony today, as it was at the first hearing, that you cannot eliminate that flashlight was at the scene of this crime?
That based on the 1985, that there was blood detected, that to end, for your question of can I eliminate it being at the scene, with Mickey Bryan being excluded as a contributor to on the flashlight, I would have to say that because she's been eliminated and because 46% of the population back in 1985 could have had type O blood, that with her being eliminated as a contributor to the flashlight, I don't think you can put the flashlight in.
So they weren't able to develop a profile from the blood stain on the flashlight, but they were able to type the blood back in 1985, and that was the same type as Mickey Bryan.
As was 46% of the population.
Correct. So you cannot eliminate Mickey Bryan or 46% of the population.
Sure.
And the other significant item on that flashlight would be the blue-green chips of plastic. That would be another reason you can't eliminate it, because those are the same chips of plastic that were found from the cartridge, or what was left of it, that were recovered also of Mickey Bryan's body during the medical examination.
And I'm going to, as I did on August 20th, I'm going to defer to the trace analyst who'd be more qualified to give that.
And the trace analyst back in 1985 analyzed that evidence and concluded that it came from the same, had the same chemical properties. We would not disagree with that.
I believe that her proper terminology wasn't it could. And so in review of her report, she said that it could be the same.
Pass it, please.
Just Your Honor, may I approach Ms. Rossi?
Yeah.
Ms. Rossi, I know you're going off the top of your head, and these reports are new, and I know which result you're thinking of. She and Joe were both eliminated as contributors on the power button, but just for clarity, on this result, it was inconclusive as to whether she was a contributor on the lens. And so, just to be clear, does that change anything, that inconclusive result? Does that change anything about your opinions?
No, ma'am.
I have nothing further.
No further questions.
Keep free to leave.
Yes, Your Honor.
Thank you for coming. You're free to go. Next.
Everything that I needed to prove to get the relief that I'm asking for from the court, which is that the court vacate this conviction and find Joe actually innocent. I approved our false testimony. So on our order designating issues, there's a question whether applicant's conviction is based on false testimony from the state's blood-spatter expert. And on the 20th of August, Ms. Rossi and Mr. Bevel were in agreement on everything but that one final issue that Ms. Rossi came and explained again for the court. Otherwise, they're in agreement. This testimony was false. I do not have to show that this was intentional. I don't have to show that. But it was false, it was unscientific, and it was unreliable. The state's expert, Mr. Bevel, said he was not qualified to testify. Even Ranger Wolf, and the point of his testimony was to show today the Rangers would not use a Bob Foreman with just a 40-hour introductory course. They wouldn't do it. And so not only have we shown today through Mr. Foreman's September 2018 affidavit, where he has now changed his opinion, but there has been a change in the field. And when we get to our junk science claim, 11073, I have to show that there's been a change in the field. And the qualifications of an expert have changed. What else did Mr. Bevel say? Mr. Bevel said that Mr. Thorman went well beyond what a competent bloodstain pattern analyst would do. And specifically, I think the court understands now, and the state has said it through cross-examination and in opening. Joe would not have even been arrested but for this flashlight. So in terms of what I have to show for whether or not this would have affected the outcome, that's a given. The state should agree on that, because they've been arguing that for 3 days and 32 years. So that's clear. And so I want to focus on what Mr. Bevel's testimony about the flashlight was. And he testified that the original expert should have stopped at saying the flashlight stains were spattered. And anything else he said, which was a lot more as we know, was well beyond what he should have said. And to say that the stains are unequivocally backspattered is false. That brings us to the disagreement that he and Ms. Rossi have. Mr. Bevel thinks, well, he cannot conclude that it is backspattered. The reason that he thinks he cannot eliminate it is what Ms. Rossi explained, and why, on its best day, perhaps that is a possible explanation, that somebody with a handle on a flashlight was spinning it around like a fan. Okay, I guess if we suspend our imagination, sure, that's possible. But is it plausible? No. And most importantly, was that consistent at all with the testimony at trial? And it wasn't. Testimony at trial was the person who did this, Joe, held this in his hand while Mickey was shot. And that the stains were consistent with being a certain distance away from a gun. And that explained the pattern that was seen. And that's just not true. It's not scientifically supportable. And the answer to ODI 5 is that yes, applicant's conviction is based on false testimony from Mr. Thorman. Applicant's due process rights are violated when a witness gives false testimony, like we said, regardless of intent, and that testimony contributed to an applicant's conviction and punishment. And the state has had no choice but to concede the significance of the flashlight in this case. Without the flashlight, Joe never even would have been arrested, and Mr. Sibley said that this week. And I just want to emphasize, because in the state's answer, now that I've had time to review it, they have said consistently this didn't matter, it was handled sufficiently on cross-examination. This mattered, it is everywhere. These are the exact same slides that I showed the court during opening. Blood spatter expert, blood spatter expert. Thorman, the blood spatter expert. We have blood on the flashlight. We have blood that was transferred, obviously, when wet. That is so important. That was telling the jury, if they were ignoring the typo serology result for a second, the jury was told that that flashlight was put in Joe's trunk when it was wet. The timing is incredibly significant, and that came from Mr. Thorman. Again, the same argument by Gary Llewellyn in rebuttal. This was the excerpt that I had taken from his closing. He says, I don't know what you thought of Bob Thorman. These rangers called him down there because he had been doing blood spatter work and had 31 years. He hadn't had a lot of formal training. It's an understatement. But this man, he came down there and looked at the scene and tells you, there ain't no way that killer didn't clean up. They're calling this case the most brutal murder down in Bosque County. We have got Mickey, not an exhibit, not on the wall, but Bob Thorman said this killer, for whatever reason, cleaned up. He is named over and over by me. The burden that I have to show, especially under 11073, is a preponderance. This is easy. He's all over this case, and it's about the flashlight today in this answer, right? The 4 pillars, money, Jack Shaw, the flashlight, no forced entry. So if that's one of the pillars, which the state is still saying today, then everything about that matters. The appellate court's legal sufficiency analysis, which for a long time I thought was maybe the only part of this case the state had read. There was enough blood in the room that the officers expressed the opinion the killer had to clean up. And the state's answer, their way of handling that is, well, Thorman isn't named in the appellate opinion. Well, the coroner's not named either, and yes, there's officers plural, but that's talking about the blood spatter testimony. It made it to the appellate court's legal sufficiency analysis. It matters. And then, also 11073. What do I have to show to get relief under 11073? That the relevant scientific evidence that is currently available and was not available and that things the court can consider when making that determination is whether the field of scientific knowledge, a testifying expert's scientific knowledge, or a scientific method on which the relevant evidence is based has changed. The state complains in its answer that we didn't show an expert's change in opinion. Today I did. I fixed it. It's better. It changed. So that is, we've taken care of that. But also, I do think that there is arguably an open question as to whether the qualifications recognized in the field, as to whether or not somebody can come in and do what Ms. Rossi and Mr. Bevel do, whether that bar has been raised, and it has. Mr. Bevel even testified his own program. Mr. Bevel himself had testified that his own program now requires a mentorship program. Ranger Wolf testified the same way. They're just not going to send officers in there doing this complicated work with just a 40-hour course. Mentorship is required. Ms. Rossi, I believe her testimony was she had to do this for 5 years under supervision. And so that, it is an open question, absolutely, but the qualifications of an expert in this field, there is a change. Rangers used to think Bob Thorman was okay, now they don't. Same thing, Mr. Bevel, the guy who trained Mr. Thorman, said, I never thought an expert would do this, you're dangerous as hell, but it's up to a court to decide. And now, even under his program, you can't do what Mr. Thorman did anymore. And I think that is sufficient to show that there has been a change in the field based on what are accepted qualifications of a BPA expert. In the state's answer, they had said that we are not an ex parte Robin land because and that's on page 16 of the state's answer. We are not faced with an ex parte Robin scenario where the state's witness becomes more educated or as a result changes his opinion. So again, I fixed that. Now we are. And I just want the court to understand that while I do think that that case absolutely controls here, there was a change in the statute between 2009, I think it is, and 2015. And still, regardless of that change in the statute, that's still where we are. Mr. Thorman's opinion has changed, and 11073 is our proper avenue for relief in addition to our Chabot claim. Also under 11073, Mr. Watson had testified that in 1985, Ms. Almanza's testimony was correct. An AP and a P30 test was the confirmatory test for the presence of semen. The state's position is, well, the jury still heard that there's not sperm cells, and so the result is the same. They still heard the same information, it was just packaged in a different way. That can't be true. I'm going to show the court all the reasons why that is not true, and that cannot save this issue. Mr. Watson did explain, though, in January 2010, because the state has also raised latches. I know they said maybe not under 11073, but just to be clear with timing, January 2010, DPS changes its protocol and says that based on a change in the field of scientific knowledge, P30 is no longer the confirmatory test for semen. It's presumptive now. That's a big difference. That's a big difference. And DPS's protocol is reflected in Defendant's Exhibit 22. And the reason this matters and would have affected the outcome of Joe's trial is because the state questioned law enforcement and cross-examined Joe extensively about the underwear. As the court knows, because of Mr. Bennett's testimony as well as Mr. McMullen's testimony, the issue in the second trial of having Joe's testimony read in from the first contained so many questions whose science we now know underlying those questions is just wrong. And so when we're looking forward about what would a new trial look like, that old cross-examination testimony can't be used anymore, or if it can, it is extremely limited. And so when we're looking at how does this change the outcome, the cross-examination of Joe is a really, really big part of that. And obviously we know the state argued to the jury that this proved that Joe was in Clifton, and today the state acknowledges that that doesn't matter. And I cited for the court on paragraph 71, page 39 of the state's answer, they call it an enigma, is now what the underwear an enigma and an oddity and is otherwise not inconsistent, or excuse me, is otherwise inconsistent with the facts of this case. I don't know why we can't agree on that then. I mean, looking for ways we can all agree on things, why we can't agree on this is beyond me. But again, to show the court specifically, and this was really, really a good example in the cross-examination of Joe by Mr. Llewellyn about what this was really used to show. Mr. Llewellyn asked Joe, have you got any idea? I don't know about perversion. I don't know about anything about killers, but do you have any idea what significance to this investigation does moist underwear in the trash can could have? And so that was the implication, that he, like I said at the beginning and opening, that he was somehow oddly aroused by shooting Mickey, that he left his semen-stained underwear in the trash. The state's now saying that that's irrelevant, but that was incredibly important at trial. It made this, as this question and excerpt from cross-examination shows, to argue that he not only killed his wife, but he's also some kind of pervert that is aroused by murder. It is absurd and it is wrong. And also, because the state keeps pointing out this inconsistency about his testimony, the significance from Mr. Watson about not only the change in science, but Mr. Watson also told us that P30 can show up in other bodily fluids, including urine. Joe's explanation for the underwear was, if you're talking about this pair of underwear in the trash that I've got, and you see a yellow stain on it, it's a urine drip from these vitamins that I took. That was discounted, and he was told he was a liar and was being dishonest about it. Now we know that that is an absolute plausible explanation. And again, appellate court's legal sufficiency analyses both discuss these semen-stained underwear. Waco in 86, Eastland in 89. Let's move on and talk about our issue, order designating issue number 3 about exculpatory evidence. So what I have to show is that the state failed to disclose evidence, regardless of the prosecution's good or bad faith. And in the state's answer, they said there is no way I can show the source of the items that I'm claiming were exculpatory. Well, I did that. I've done that. I've showed the source of every item that I have claimed is exculpatory, where it came from, and Mr. McMullen's testimony. It was kind of, not that after 3.5 years of doing this, I wouldn't have any experience hearing it, but it was kind of amazing. He literally said, this case was treated differently. This was a high-profile case. We had a policy where attorneys could come in and access and have open file, and this case was treated differently. We withheld everything until the witness testified, and then we gave it to him. I thought that has to be some type of presumption that Joe's attorneys didn't get what they were entitled to. So let's walk through everything. I showed the court where it came from, when it was discovered, and why it's exculpatory. So Defendant's Exhibit 28 is a police department phone message that says, here's another suspect you should be worried about. I think he is responsible, potentially, for both the Judy and Mrs. Bryan cases. Go look at him. That was a couple days after Mickey was found dead. So why is that important? It implicates another suspect. Mr. McDonald had said, if Mr. Malone and Mr. McDonald, his dad, had had any information about alternative suspects, it would have been used. And we can look at the trial transcript and see. They had Ranger Wiley's report and another report, Doris Patrick's report, that yes, does discuss alternative suspects. There's nothing in there about anything that I've shown the court. And so based on Mr. McDonald, who said, I am familiar with the habits and routine and custom of Mr. Malone and Mr. McDonald, I can tell you that just because, like the state's saying, just because we don't have the file doesn't mean I can't show what I need to show. And the absence of a file doesn't mean that they got it, or it doesn't mean we can presume they got it. We can look at the trial transcripts and because of their habits and routine and see that because there's no cross-examination about it and there's no witnesses that were called, that we know they didn't get this material. Stopper's report. I walked through this with Mr. McMullen. This was in the custody of law enforcement. It says on page 3 or 4, it went to Mr. Wiley's file, and then it went to the court, and then it went to Mr. McMullen's office. So even if Mr. McMullen wants to say I didn't have it at the time, which I believe he wouldn't have had it until after trial was over, but it was within that 30-day window where Joe's attorneys, if it was produced, could have filed a motion for new trial. And just because Mr. McMullen may say he didn't have it, that doesn't mean that he is absolved of that. Cause versus Whitley, right? Anything in the custody of law enforcement, that is still the obligation of the state and the prosecutor. And that's where we found it, in the custody of law enforcement and also in the DA's office file. Defendant's Exhibit 35, the officer notes regarding the flashlight discovery. Mr. Wiley was really helpful in telling the court the summary of the story of the discovery of the flashlight. The story of the flashlight was exactly as he said, as Mr. Wiley told it. And Defendant's Exhibit 35 gives a different account. It says Charlie Blue was with another friend when the flashlight was discovered, and that Charlie Blue and that friend went home to go call Bud Saunders. That's a different version of events. That is impeachment evidence about the most important piece of evidence in this case, and it is a contradiction. It's impeachment by contradiction. Mr. Blue and Mr. Saunders said they were together. We now have something that says Mr. Blue was with somebody else, and while Mr. Saunders was told about it, he was called. He wasn't present. That is a big contradiction. Mr. Wiley told the court that he believed that Mickey could not have been killed after 6 o'clock because the alarm hadn't been turned off. Well, Defendant's Exhibit 36 says a witness who was present, Rex Daniels, at trial, apparently through this officer note, had said that the alarm clock was turned off. Right, Mr. Wiley explained he knew it wasn't because then it went off again 12 hours later. That's an important part of timeline. Mr. McDonald also told the court one of the reasons he was always of the personal opinion that Joe could not have done this is because the timeline made no sense. Anything about timeline is important, and that's why that is significant. Defendant's Exhibit 48. Officer notes, again, regarding another alternate suspect. The state is still saying in their answer, this mountain of evidence, which Professor Sayre was right, isn't a mountain, more like a bump, points all to Joe, right? Ex parte Miles says, why is information about an alternate suspect important? Because when the state says at trial, all of this only points to one person and nobody else. Evidence of somebody else being responsible is absolutely important. And Joe had an alibi. He was in Austin. We'll get back to the Jack Shaw story and why that is, the state misunderstands what that was all about. Professor Sayre handled that. But an alternate suspect, Mr. McDonald told his court, would have been used by Joe's attorneys. It was incredibly, incredibly important. And in a case like this, when the client is somebody else, somewhere else, as a defense attorney, any other explanation you can give to a jury as to who actually did this is not only something you want to be able to do, it is something you must do, but you can only do it if you have the information. And Joe's attorneys didn't have that information. And then Defense Exhibit 47, these autopsy notes. The state says in its answer that in that it shows that Joe's attorneys had those records. That is a misreading of the correspondence attached to that exhibit. In November of 1985, Joe's attorneys request a copy of the autopsy from Swift's. In December, they are told very specifically by Mr. McMullen what they can go to Swift's and have access to. And it was information about fingerprints, scientific reports, which these are not, these are notes, these are not reports, and photographs. So very limited in 1985 about what Joe's attorneys were given access to. In May of 1989, I think it's May 26th of 1989, again, in Defendant's Exhibit 47, there is a letter from Mr. McMullen to Swift saying, give Joe's attorneys access to whatever they want. And I corrected myself. I told the court that Joe's trial did not start on the 29th, it actually started on the 21st. And so less than 30 days before is the documentation we have saying that they were allowed to have access to everything. May 26, 1989, less than a month before, for the first time, access. That can't be the way around disclosing something as important as a note about defensive wounds. right? The medical examiner had testified that he didn't believe there were any defensive wounds. These notes would have been impeachment for Joe's attorneys to say, are you sure we've got these notes that were written by another person in your office? They say something different. Can you work through that with us? That's incredibly important. They didn't have it. From Judge Morgan to the parties about a review of the file in December of 1985. Well, most of what I am telling the court is Brady was not in existence until after. And so if the state thinks that that letter from Judge Morgan on December 20th of 85 is dispositive, because when the state is alleging latches and prejudice and saying we've waited so long, I was still finding evidence in this case during this proceeding. That's incredible. That should astonish everybody in this courtroom, that 32 years later, I am still finding stuff. That is unbelievable. And so for them to say latches when they were still, Mr. Carpenter is the one that went to Joe Wiley's house to get that file. Defendants exhibits 37, 38, and 39. Those are from Joe Wiley's file. So even let's say Joe had filed an application earlier, we would be back here fighting about whether or not a subsequent writ is barred. Thank God he hadn't filed anything sooner. And Dennis joins Clifton Police Department. Our three witnesses, Linda, Susie, and Cindy, all talked about their experiences. I also think it should amaze the court that I'm still finding, right, the state saying latches, that there's nobody around, but I'm still finding live witnesses, one of whom I had just met for the first time in June, that they had these awful experiences. Grown women, not women, young women, Miss Whitley's age, grown women. Judy is reported missing in June of 1985. She's discovered deceased the next day. And Joe Wiley told the court he was a suspect in the Whitley case in 1985, and that's why Mr. Wiley's testimony about him taking Dennis for a polygraph, looking into his background. Joe has always said this: if y'all are telling me that flashlight in the trunk of my car is what you said it is, that I was in Austin. He has always said that. And so when we're thinking through, like Professor Sayre said, that maybe somebody's running a scam on him, wouldn't a police officer know how to? Joe Wiley's testimony, he said Mr. Dunlap had been, and he confirmed, had been under investigation by the FBI for narcotics distribution, was running prostitutes with young girls, and doing all of this other illicit activity that would be consistent with somebody who had just killed a young girl a couple days earlier. There is a predator in this community. Law enforcement knew it at the time. In July, Dennis quits. Less than 6 months later, Mrs. Bryan is murdered while Joe is in Austin. Next day, Joe Wiley is notified that Dennis Dunlap is still in the Waco, Clifton area. I said I put up there October 11th. That is because in Defendant's Exhibit 38, that note that Mr. Wiley read to the court, he is told that Mr. Dunlap was at the Lazy Fisherman the Friday night before with a question mark. So I went on the calendar, and that's where October 11th comes from. Dennis Dunlap commits suicide, and Rosenberg PD was the agency that reached out to Clifton PD to say, hey, we have this event down here, there is something going on. And we showed officer notes where in the investigation of Dennis Dunlap's suicide, Joe and Mickey's name are both on it. So in 1996, why, if I'm just pulling this out of thin air and it's weak like the state's telling me and there's nothing to it, why on a random suicide of an officer in a little town like Rosenberg PD are they talking about Mickey and Joe Bryan in their notes and investigation of the case? This isn't crazy. This isn't like me just pulling this out of thin air. What is the other explanation for that? But there is a connection between the two. And Mr. McMullen and I had walked through, right? Clifton PD, around that time, May 29th, had sent that fax regarding the anonymous letter to Mr. McMullen and said somebody else is responsible. Dennis killed Whitley, and a friend of his, Jimmy, is the one who's responsible for Mrs. Bryan. Again, alternate suspects are important. The DA's office had that information in 1996. And then, in July of '96, Ranger Nix and Rex Childress go and interview Dunlap's ex-wife, and she is the one who says that Dunlap had told her that he was with Mickey the night she was killed. And those are Defendants Exhibits 42 and 43. And then in December of '96, Mr. McMullen is having a meeting with Ranger Nix and Clifton PD Sergeant Rex Childress about Dennis Dunlap and whether or not are we going to close this case. And 25 days later, he puts in writing to B.J. Shepard, Mr. McMullen says the Whitley case is pending disposition. Absent any other new information, I'm going to consider this case closed, and I'm going to consider Dennis Dunlap officially the perpetrator of this crime. He's deceased, I can't prosecute him, but we're closing out the case. And then, 3 years later, there's an announcement in the newspaper that this case is closed. Mr. Dunlap, as determined by law enforcement, is responsible, and that's Defendants Exhibit 44. And then, just to bring it all to the present, the first time, and this was before me, Mr. Reeves had sought testing, DNA testing in Joe's case was in January of 2012. He gets the report back in June of 2012, so 6 months later. In September of 2012, the state requests DNA testing in the Whitley case. How do I know that? Where is that coming from? And my citation to the court is that's going to be the state's October motion for continuance on page 2, which I excerpted, and the state requests testing in the Whitley case, and I believe says they didn't hear anything back. And then in August, they say they renew that request. And then in October, in this motion, the state says the Judy Whitley case is an incomplete investigation. And then Chief Hendricks comes to court and tells this court, Clifton Police Department has considered this case closed since the 90s.
And grabbed her and threw her against the ball head that she said, and grabbed her around the neck. Now, I don't know if that's true or not, though. That's what she said.
You told us a lot here today. At any time, did he ever mention any other murders or any other cases that you recall?
I think in the clippings, it was in the clippings, either I read it in the clippings or he told me about it was the lady where the principal murdered her. He said the principal murdered his wife, wasn't it? All he ever told me about that was, I can't remember if they sent the clippings or he told me. All he told me was that he dated her. He's dating that lady. That she was separated from her husband or something, and that he was going, I want to say, I'm not for sure, he dropped her off that night or that evening, and they had said that they were going to break up. I mean, they weren't going to see each other anymore, and she was going back to her husband. But I think she didn't get to tell her husband she went to go back to him, that someone had killed her. I don't know if it was that night or what, you know. That's all I know about that. And then how they found, then they find a weapon in a man's trunk or somewhere that killed the lady. Is what he was telling me, and that they wiped the records clean, that he's supposed to have been staying at some other place. He went to a convention or something, and they couldn't find out that he was really at a convention, that the records were all wiped clean. He said he was at a convention, but they couldn't find anybody to prove that he was at the convention or some kind of school conference, you know. That's all I know about that one there.
And have you ever, whether Dennis was there or not, heard anyone else mention anything about any other crimes, or any other murders, or any other suspicious circumstances?
That's the only two that I know about. Those two there, that I can remember.
And I don't call the be fair. That cannot be right. That cannot person. There is no way. If the state's theory is he was trying to make this look like a robbery or burglary, whatever, why would he have reported the money missing? Isn't he doing good that it hasn't been discovered? Why would you report it? It is completely inconsistent with that proposition that he's trying to make this look like somebody broke into his house, which also is the reason that this inconsistency they keep focusing on about the screen, which is non-existent. He always said the same thing. But regardless, are definitively facts battered from close proximity to a gunshot, and I'm hedging just to whatever Mr. Bevel's turning the flashlight like a fan thing is for, which is not much. No bad false signs that lets the state manufacture a clean up theory to explain why there is absolutely no other evidence of this crime that can be tied to Joe, because he was an officer. No underwear at all, but definitely no underwear to scientifically support a state's theory that Joe's semen was present at the crime scene months before Mrs. Bryan was killed, and in 1996 admitted to a credible witness that he was with Mrs. Bryan the night she was killed. Judge, I appreciate maybe being on this side of the bar. I don't get to say this. I may not get to say this all the time. The law, the truth. Joe was in Austin. He was, never left. He was there the whole time. And the right thing, they are all the same. He is innocent. Always has been. If they're going to retry him, make them do it the right way. Because they've never done it the right way. Please fix this.
Prior to making any findings of fact and conclusions of law, because this adequately addresses and rebuts every argument that counsel just made. In this case, as Mrs. Freud just referred to, there really is no substitute for reviewing the entirety of the record. Whenever you take something out of context, you alter its meaning. Again, we've had two juries that have found Mr. Bryan guilty and have assessed a 99-year punishment in this case. By taking the blood spatter testimony in particular out of its context, you're altering its meaning. You don't have the supporting testimony of the Texas Ranger or the BPS chemist or the host of other witnesses that brought this evidence in front of the jury. And I think, again, that is covered in our brief. The only issue that has not been adequately addressed is the court is aware now that counsel filed an amended writ after the conclusion of our first writ hearing in August. That amended writ raises a new claim. It's now alleging a due process violation for the testimony of the blood spatter witness. So we would ask with this court's permission to file a supplemental response and to exceed the word count in order to address that. And the reason being, when in asking for bringing a new claim in front of this court, what they have done is when the evidence didn't fit their theory of the case, they changed the claim. It was clear after the first hearing that there was an issue with the 11073 claim. So what they did is they went out and they got Mr. Thorman an affidavit from Mr. Thorman, a second affidavit that addressed the 11073 issue. They then changed the claim that pertains to this false evidence by changing the constitutional or legal basis for that claim. And that's because the evidence presented at the first writ hearing, they did not meet their burden of proof. And so what they did then was they just changed the claim, alleging a due process violation. And the only way that, Your Honor, I think that's more than that.
You address that. Now, we need comparison findings of fact, including when each side has prepared.
Your Honor, we would ask at the initial writ hearing, I believe the court gave us a month after we had received the reporter's record so that we could incorporate the findings from that hearing and now from this hearing into the proposed findings of fact. So I guess just out of
Satisfactory with you?
Yes, sir. My hope is we can all look at a calendar together and just maybe now that we were able to get this set so quick, have just a day where we could have everything done all together. And I believe Ms. Janice got us our reporter's record on the 7th.
Sorry?
I don't understand that as if you have weird stuff
Okay, text me later.
Hey, Christine, first your name, just look for it, and your name and spell it for me.
Celestina Rossi, CELESTINA
In your Montgomery County Sheriff's Office.
with the Montgomery County Sheriff's Office Crime Lab.
Tell me how long have you been with the Sheriff's Office now?
October 4th will be 21 years,
And of this time, how long crime scene?
16 and a half.
What got you basically turned into the state's expert on blood splatter? I mean, you've been around now for a while. I've seen a couple court cases with you, and what got you into the blood splatter?
It's spatter.
Spatter.
I really just, when I came in the lab and we were exposed to a lot of different disciplines, fingerprints, blood stain, and I really just was fascinated by blood stain pattern analysis, that, you know, the story that it told, the hints that it gave on you know, actions during a bloodletting event, and you know, my intrigue in that just kept me, you know, trying to learn as much as I could about it.
Tell me, explain more about blood spatter, what it is actually.
So it's just the, you know, when I mean, blood is a fluid, responds in a predictable manner, so it deals with fluid dynamics, and the, you know, amount of force that is applied to a blood source determines what size of the staining that you're going to get. So it's an inverse relationship. The greater the force, the smaller the stain, and then the characteristics of different patterns will tell you the mechanism or the action that caused it. So if we have spatter stains in circular to elliptical, you know, orientation, and they are somewhat oriented in a line or in a like curvilinear pattern, then that can tell you that it's either a drip trail, it's cast off, or it's a projected pattern. If we have stains that radiate, so go from circle stains to elliptical stains in like a V shape or a cone shape, or like, you know, look like half of a bow tie, then that tells you that it was, you know, that's an impact event. So something has struck a source of blood, causing it to radiate outward. And so just by knowing what the pattern looks like, what the characteristics of the pattern are, that can tell you maybe what is going on. And so that, to me, it's almost like putting together a puzzle piece. You're looking at something and having to determine, you know, the cause and effect.
Now, basically, Texas Forensic Sciences contacted you and
Yes,
asked you about this case here. Tell me how they contacted you, and what this case is just kind of briefly on this case. What was it?
So they received 2 complaints on 2 cases, one out of Houston and one out of Bosque/Commanche County, in reference to some bloodstain testimony. And so they were looking, the commission, which is appointed, they're appointed by the governor, they were looking into these 2 specific complaints, which then caused them to question what the criteria was for someone to be able to go into a courtroom and testify to bloodstain pattern analysis. And so because they were starting to ask questions, they had one of their quarterly meetings in November where bloodstain pattern analysis was being discussed. And so from the Montgomery County Sheriff's Office, we live streamed that meeting so that we could listen to hear what the discussion was about. And it was, you know, it was apparent that there wasn't a lot within the commission known about, you know, what should be the criteria for a court testifying bloodstain pattern analyst. And so I reached out to some of the folks on the commission, asking to be able to have an opportunity to speak with them, to educate them on, you know, what bloodstain pattern analysis is, how it's being taught in Texas. I instruct with one of my, you know, the Montgomery County alumni who left Montgomery County to go to Texas A&M Engineering Extension Service, Christine Ramirez. So we teach a 40-hour basic course. And so I asked the commission for an opportunity to explain to them, what we teach. This is one step amongst many steps that one would need to take. And so I got that opportunity. So I testified to the commission in February, or in January, and then in February they started issuing criteria, which was that in order to be able to render expert opinion, a lab would have to have an accreditation in whatever discipline that they were going to testify in. So whether it be blood stain pattern analysis, crime scene reconstruction, shooting incident reconstruction. And so that's kind of where my relationship with the commission began. I then started attending the meetings so that I could, hear what they were discussing, and then if needed, I could, add or offer additional information. And then in May, the commission approached me and asked if I could look at the 2 cases that they had complaints on. And so I'm not able to make that decision. That has to be made by the sheriff, and so it went up through the chain of command. I personally recused myself from the case out of Houston just because of the people that were involved in that case. I felt like that they needed someone else to look at it, but I was specifically asked to look at the Joe Bryan case, and so that's how I got involved in why we're here today.
Tell me a little bit about the Joe Bryan case.
So Joe Bryan was the high school principal in Clifton, Texas in 1985, and he was attending a principal conference in Austin, which round trip is 262 miles. And while he was in Austin at this conference, his wife was murdered. And the detective that was called in from Harker Heights Police Department by the Rangers, so he came from Harker Heights to Clifton and issued a bloodstain report, and then subsequently testified in trial. And the testimony that he gave was not only not scientific, it did not follow the methodology of bloodstain pattern analysis. And so when I was asked to look at his testimony specifically, my determination was that it wasn't scientifically supported. It wasn't the methodology in 1985, nor was it the methodology, that we follow today in 2018, and that even up till what we learned today, that Mr. Thorman still doesn't have a working knowledge of proper bloodstain pattern analysis, which, is still, even today, very concerning.
What about the Joe Bryan? This has been going on. The hearing was last August, I think it was, and then we come back again today.
August 20th, and now we're back.
What has been turned on some of this so far? What have they found so far? I mean, the flashlight is coming into this real heavy.
Sure. So that was what appears to be the key piece of evidence in 1985 is a flashlight that was found in his trunk that they theorized was in close proximity to a spattering event. There was testimony that said that Mr. Bryan was holding the flashlight. It has now been determined today that, Joe Bryan and Mickey Bryan are excluded as contributors to the handle and the button on the flashlight, and that out of 9 stains that were tested, all of them except one tested presumptively negative for blood, and the one stain that did react has no results. And so, from the testing that was done in 85 up till today, there has, the flashlight is very suspect in the chain of custody of, when it was located, and then, that the staining on the flashlight isn't even blood.
Now he was at the conference. How do they put him at the crime scene if he was at the conference, and how did they get a conviction out of this?
So they allege that after speaking to his wife Mickey on the phone, that sometime after that time, which was late in the evening, 9:30 to 10 o'clock, that he got into his car in a rainstorm with an eye condition that prevented him from driving at night, drove 262 miles round trip, shot his wife 4 times holding a flashlight, cleaned up, disposed of the weapon and his clothing somewhere, returned to the Hyatt Regency in Austin, and then met his friends at 7 o'clock in the morning for breakfast and attended this conference until the superintendent and the assistant principal came to tell him that he needed to come back to Clifton. And so the state alleges that all of these things happened, and that Joe was the suspect.
Now, they've got other theories on this. I mean, there's been some other theories going around with another suspect, possibly a serial type deal.
Yes.
Tell me a little about that.
So they have a viable suspect who, there were lots of witnesses, even last month that came, that talked about this suspect, and the suspect's ex-wife actually gave a recorded statement to the Rangers in 1996 talking about a 17-year-old that was brutally murdered, and then the suspect also admitted to his then ex-wife that he was with Mickey Bryan the night that she was murdered, but then offered that, you know, when he left her, she was alive and well. And so he actually put himself with Mickey Bryan during the time that Joe was talking to her on the phone from Austin. So he actually alibied himself as being with her, and then, you know, made the allegation that that's why Joe would have killed her. That was the motive, why he would kill her, because of this maybe known affair. However, there is nobody in Joe and Mickey Bryan's life that ever came forward to say they were having problems, to ever say that they were never not together, or that there was any way that, you know, Mickey Bryan was having any outside relationship.
Now, wasn't he claiming at the time wasn't he claiming that they were together and that she had said she was something about going back with her husband, that breaking it off there?
Sure, and he offered that they were separated at the time. However, Joe left from their residence that day to go to Austin.
Okay. And now the suspect, who was the suspect?
So the suspect is a ex-Clifton police officer by the name of Dunlap.
And Dunlap stayed with Clifton for a while, then left.
He
went down
left
to
shortly
Rosenberg.
after the Mickey Bryan investigation. I think that a lot of people were naming him as a person of interest in both the Judy Whitley homicide and the Mickey Bryan homicide, and so he left town. I think he went to Dallas for a while before then ending up in Rosenberg. And then in '96, a reporter from the Clifton paper went down to interview him about his name coming up in these two events, and I believe that he was down there on a Friday, and Dunlap hung himself on Monday.
Kind of, I wonder why that came about, huh? So he was a police officer here in Clifton at the time?
Yes.
Okay. All right. So where does it stand now with the case?
So it appears that the judge is going to offer or allow the state and the defense to offer their findings of facts and conclusions of law based on all of the hearing transcripts. And so he's given them a deadline of November 10th, which is a Saturday, so I don't know if he's going to hear it the Friday before or if they have until, you know, midnight on the 9th to file those briefs for him to then, determine, and then I think his findings will go to the Court of Criminal Appeals.
Okay. So no telling if Ms. Brown will be out for Christmas or not.
You know, we can only hope.
I hear a lot of support here today.
Yes, sir.
Now, some of the supporters are actually victims' family. We're actually paying the attorneys to help get him out.
Yep.
This kind of says something right there.
Yes, sir.
Tell me a little about that.
You know, and I really just, other than seeing them in the courtroom wearing their supportive shirts, you know, I've just sat in the front pew and have been mostly removed from that, but it sure does seem like there are a lot of people here, classmates of both he and Mickey's, as well as, you know, family from both sides that have been here in support.